Is the U.S. government preparing to widen the list of people who could lose their American citizenship even after they've already become citizens? That's the question a lot of immigrants and naturalized Americans are quietly asking right now as a new bill introduced in both the House and the Senate begins to attract attention. The proposal is called the FAS Fraud Accountability Act. On the surface, it's being sold as a response to a recent high-profile fraud scandal. But when you read the text closely, you can see that its potential reach goes much further than that headline case. At its core, this bill is not just about punishing fraud. It's about changing how denaturalization could be used in the United States. You're watching Immigration Updates, Hubbity, where we take complex, emotionally charged immigration and citizenship topics and break them down calmly, clearly, and accurately. If you want to stay informed without unnecessary panic, you're in the right place. Before we go deeper, a quick but important disclaimer. Nothing in this video is legal advice. I am not your lawyer, I am not a government official, and I do not work for USCIS, DHS, or the Department of Justice. I am explaining publicly available information and legal concepts in plain language so you can understand what's being proposed and what it might mean in theory. If you have questions about your own immigration or citizenship situation, you should speak with a qualified U.S. immigration or criminal defense attorney. Now, let's talk about what this bill actually does, and just as importantly, what it doesn't do yet. The Fraud Accountability Act was introduced after a daycare-related fraud case that drew national media coverage and angered a lot of people. Lawmakers framed the bill as a tough response, a way to hold people accountable when they abuse public funds or commit serious fraud. But when you look beyond the press conferences and into the legal language, you find a major part of the bill focuses on immigration consequences, especially for lawful permanent residents and naturalized U.S. citizens. The biggest proposed change concerns denaturalization, the process of taking citizenship away from someone who has already become a U.S. citizen. Under current law, denaturalization is generally limited to very specific situations. In simple terms, the U.S. government can try to denaturalize someone when they argue that the person was never actually eligible for citizenship in the first place, and citizenship was obtained because of fraud or material misrepresentation during the naturalization process. In other words, today's system for denaturalization usually looks backwards at how a person got U.S. citizenship. The logic is, if you lied your way in, citizenship should never have been granted, so we're undoing that mistake. Crimes that happen after someone becomes a U.S. citizen are normally handled by the criminal justice system, not by deportation or denaturalization. A citizen, whether born in the U.S. or naturalized, who commits fraud can be charged with a crime, tried in a criminal court, fined, put on probation, or sentenced to prison. But under current practice, their U.S. citizenship itself is not used as an extra punishment for wrongdoing that happened after they became a citizen. The Fraud Accountability Act proposes to change that. As written, the bill would allow, and in some situations require, the U.S. government to revoke the citizenship of naturalized Americans for certain kinds of fraud committed after they became U.S. citizens. That is a fundamental shift. Instead of denaturalization being a tool reserved mainly for people who lied during the naturalization process, it would become an additional consequence of post-citizenship criminal behavior. That's why this bill is getting so much attention from legal experts, even though, as of now, it is only a proposal and not law. To understand how big a change this would be, we need to briefly review how denaturalization works today. Right now, most denaturalization cases are civil, not criminal, proceedings, are brought in federal civil court. Focus on whether the person was legally eligible for naturalization at the time it was granted. Examples of traditional denaturalization cases include people who hid serious crimes or human rights abuses from their past, people who lied about their identity, marital status, or other key eligibility factors when they applied for naturalization. Very rare, high-profile cases involving war crimes or similar issues. In these situations, the government argues, if the truth had been known, you never would have been approved. The remedy is to unwind the naturalization. This is very different from using denaturalization as a penalty for crimes committed later. The Fraud Accountability Act, as drafted, would change that by 1. Moving denaturalization into the criminal case itself. Instead of a separate civil lawsuit, denaturalization would be handled as part of the same criminal case in which a person is convicted of fraud. 2. Making denaturalization mandatory, not discretionary, for certain fraud convictions. The bill uses the language "shall denaturalize" rather than "may denaturalize." That one word, "shall," matters. It means the judge would not have flexibility. If the conviction fits the criteria in the bill, the court would be obligated to start the denaturalization process. 3. Tying denaturalization directly to criminal fraud statutes. Today, crimes after citizenship are punished through fines and prison, not through loss of citizenship. Under the bill, certain fraud convictions would automatically trigger denaturalization proceedings, treating loss of citizenship as part of the sentencing landscape. That is a dramatic philosophical change, from correcting earlier eligibility errors to using citizenship status as a conditional benefit that can later be revoked. The bill does not stop there. It also affects how fraud itself is defined and treated for immigration purposes. Under current immigration law, not all fraud is treated equally. Certain serious fraud crimes can already make non-citizens, like green card holders, deportable. For that to happen, there is often a requirement that the loss to victims, including the government, is at least $10,000, or the fraud meets specific definitions used in immigration statutes. That $10,000 threshold acts as a line separating more serious frauds from lower-level cases that might still be crimes, but are considered less significant from an immigration standpoint. The Fraud Accountability Act, as drafted, would eliminate that threshold. It would treat any qualifying fraud conviction, whether the amount involved was $100, $1,000, or $1,000, as enough to trigger immigration consequences. That means for lawful permanent residents, green card holders, any fraud conviction that fits the bill's definition could potentially make them deportable, even if the financial amount involved was relatively small. For naturalized citizens, those same types of fraud convictions could become the basis for mandatory denaturalization, not just in large-scale scandals, but across a wide range of cases. The bill does this by modifying how certain parts of the Immigration and Nationality Act define fraud and deportability. It then ties those definitions into the denaturalization framework for naturalized citizens. Up to now, there has been a very clear line. Deportation and deportability rules apply to non-citizens, undocumented individuals, people on visas, and lawful permanent residents. Once someone becomes a U.S. citizen, they are generally outside the deportation framework and are instead subject to the criminal justice system like any other citizen. This proposal begins to blur that line by importing deportation-style rules into the world of denaturalization. Put differently, it applies immigration removal logic to naturalized U.S. citizens. On top of that, the bill includes a retroactive element. As currently written, it says that these new rules and definitions would apply back to fraud convictions dating as far back as September 30th, 1996. That's nearly 3 decades. In theory, that means that any green card holder with a fraud conviction since 1996 could face deportation under this new standard. Any naturalized citizen with a qualifying fraud conviction in that time frame could face denaturalization proceedings. Now, does that mean that tomorrow thousands of people will lose their citizenship if this bill passes? No. We need to be careful and realistic here. Retroactivity is one of the most controversial parts of the proposal and would be a prime target for constitutional challenges. And that brings us to a very important part of the conversation: constitutional law and legal precedent. The Supreme Court of the United States has weighed in multiple times on the question of citizenship and Congress's power to take it away. Key points from those decisions include: once U.S. citizenship is properly granted, Congress has very limited power to strip it away. In general, citizenship can only be lost through voluntary actions by the individual, such as voluntarily renouncing citizenship or knowingly committing certain acts with the intent to give it up. The court has pushed back strongly against the idea that Congress can just invent new ways to involuntarily remove citizenship as a punishment. There is also an important principle of equality between natural-born and naturalized citizens. The Supreme Court has held that, in nearly all respects, naturalized citizens have the 5 same constitutional protections as citizens by birth, creating a system where Natural-born citizens can never lose citizenship for committing fraud, but naturalized citizens can lose citizenship for that same conduct, raises serious equal protection questions under the Constitution. That does not mean Congress is completely powerless to legislate in this area, but it does mean any law that treats naturalized citizens as having a conditional citizenship, one that can be revoked for later behavior in ways that do not apply to natural-born citizens, will be heavily scrutinized and likely challenged in court. That's why many legal experts across the political spectrum believe the Fraud Accountability Act, as currently drafted, would face intense constitutional challenges if it ever passed. Now let's step back from the legal theory and talk about where things really stand right now, or stare, as of this moment. The Fraud Accountability Act is a gross bill EU, a proposal. It has been introduced in Congress, but it has not passed the House or the Senate. It has not been signed by the President. It is not law. Every year, hundreds of bills are introduced in Congress, especially in response to specific news events or scandals. Most of them never make it out of committee. Many are political statements designed to send a message to voters. We are doing something about this issue. This bill should be viewed first and foremost in that context, as a harsh signals of what some lawmakers want, as part of a larger political conversation about fraud and immigration, not as a rule that has already been imposed on citizens or green card holders. It is also fair to say that even if some version of this bill were to move forward, it would almost certainly be challenged in court immediately. The conflict with past Supreme Court decisions, the retroactivity, and the unequal treatment of naturalized citizens are all serious legal issues. So what does that mean for USA? If you're a naturalized U.S. citizen watching this, the most important thing to understand is nothing has changed yet about your citizenship rights. You do not face new denaturalization rules today because of this bill. The existing standards for denaturalization, focused on fraud or misrepresentation during the naturalization process, are still the ones in effect. If you're a lawful permanent resident, green card holder, the bill is also a reminder of something that is already true. Fraud convictions can be extremely dangerous. For your immigration status under current law, even without this bill, that includes fraud against the government, benefits fraud, tax fraud, and some types of fraud against private parties. This proposal simply highlights how important it is for non-citizens and naturalized citizens alike to avoid any involvement in fraud, however small it might seem. Things like signing something you know is inaccurate to help a friend, claiming income, dependents, or benefits you don't qualify for. Participating in schemes involving government benefits, insurance claims, or loans can already have serious immigration consequences today. The bigger takeaway is this: you do not need to panic about the Fraud Accountability Act. It is not law, but you probably want to take it as a loud reminder that immigration and citizenship remain deeply political and legally sensitive topics in the U.S. Staying informed is your best protection against both unnecessary fear and real risk. If you're a citizen, especially a naturalized citizen, it's wise to keep your documents and records organized, file honest tax returns, stay far away from anything that even looks like fraud. If you are ever investigated or charged with a crime, talk to attorneys who understand both criminal and immigration law before agreeing to any plea. If you're a green card holder, know that many forms of fraud can already make you deportable. Understand that a fraud conviction, even if the amount involved is under $10,000, can still cause you immigration trouble right now, depending on the exact offense. Get competent legal advice immediately if you're ever charged or under investigation. The good news is that, for the overwhelming majority of naturalized citizens and lawful permanent residents who live their lives honestly, follow the rules, and stay aware. There is no immediate danger from this proposal. The key is, don't let panic drive you. Don't let headlines alone shape your understanding. Pay attention to what actually gets passed into law and what gets stopped or struck down. If you found this breakdown from Immigration Updates Hub helpful, make sure to subscribe and turn on notifications so you don't miss future videos where we separate political noise from legal reality. If you have questions about how proposals like this could work in real life, or you're just worried about what it could mean for people like you, feel free to share your thoughts in the comments. I read as many as I can, and your questions help shape future content. Staying engaged, calm, and informed is the best defense against unnecessary fear in a fast-moving immigration debate.